next week, I'm sorry, Wednesday, we'll do another drawing. All right, how many of you at this point do not have clickers? And I apologize, usually we pass these out beforehand, but the library is a little slow today. All right, what we're going to do now for the next couple of hours, and we should be out of here easily by 5 o'clock, maybe a little bit before, we're going to talk about the MBE. Many of the sessions, as I mentioned before, are going to be more oriented toward Florida, but today's is not. A question that I have for you, though, so that I can kind of judge the crowd, if you will. How many of you have taken ALS? Most of you. Good. All right. So, it doesn't mean we're not going to do what we're doing today, but what it should mean is that most of what I'm saying is going to reaffirm what you already learned. Now, you might say, well, let's just move on then. But we have found, and we've been told, and research has shown, that repetition is important when it comes to bar learning. So you don't hear something once, you hear it twice, you hear it 3 times. The more you hear it, the more it sinks in. And as we go through the class today, I am going to expect you all to participate, because participation is an important part of the process. So I don't want you to just sit there like lumps, right? You're going to be telling me the things instead of me telling you, and that's why we've got the clickers, because we're going to see how you do. Now, some of the subject, I have questions, by the way, in the packet that cover all of the 7 MBE subjects. It's really 8, but they call it 7, as you well know, because they combine criminal law and crim pro. So what are the subjects? We start, I'm going in alphabetical order, civil procedure, right? Federal rules of civil procedure, constitutional law, federal constitutional law, contracts, again, MBE style contracts, which is both common law and Article 2, criminal law, criminal procedure, evidence, property, a subject everybody loves to hate, and torts, all again MBE. So those are your subjects. If you were in doubt about what you're going to be tested on the MBE, it is those 7/8 subjects. And approximately the same number for each subject out of the 200 MBE questions. You will get those questions all mixed up. 100 in the morning, 100 in the afternoon. And just to make sure that nobody cheats, the packet that Dayron has is going to be different from the packet that Adrian has, that's going to be different from the packet that Claire has, etc., etc. They mix them up. There will be the same 200 questions. Everybody gets the same 200 questions, but not in the same order. So, if, for example, you walk out of the morning going, piece of cake. Maybe you got all the easy questions. You might have. And somebody else says, the worst morning I ever had. It might have been the worst morning because the worst questions were in the packet. Do not assume that you're right or that a person is wrong in judging the questions. And someone may say, wow, there were just so many evidence questions. And you go, what? I didn't have any evidence questions. Yeah, that might be exactly correct. Understand again then, that they're all mixed up in a different order to prevent people from cheating. Basic things, again, I'm assuming you know, but repetition helps. How many choices on the MBE are you going to have? 4, right? You don't have 3, you don't have 5, you have 4. Every question will have 4 choices, and only 4 choices. Do not bubble in E. And everybody laughs, but you'd be surprised when, because those of you who've had me in class, you know I do MBE style multiple choice questions, 4 choices. Every time somebody bubbles in E or F or G, you have a 25% chance of getting the right answer if you pick A, B, C, or D. You have a 0% chance of getting the right answer if you bubble in E, F, or G. So keep that in mind, right? And bubble in something. I'm sure you've already probably been told, bubble in something, whatever your commercial course says, bubble in B, bubble in C, it doesn't, you've got a 25% chance of getting the right answer. If you don't bubble in anything, you will get the question wrong. And fortunately, they do not take off for wrong answers. So the name of the game is to get the 136 scale, but you get it by bubbling in. You never get a point by not bubbling in. And even worse, if you don't bubble in because you're thinking about a question and you're not sure, if you don't mark the place on the Scantron sheet, then you can screw up your Scantron sheet going forward. And I've seen it happen. I've seen people get down to the bottom and be one question off. Oh, painful. So take the questions in order. Do not jump around. Take them in order. If you're not sure on a question and you want to come back later, bubble something in and circle it on your question sheet or something and come back. But make sure that you go in order and you bubble everything in. Now, speed. I'm sure you all thought a lot about speed. And I got to tell you, speed kills. I always say speed kills when it comes to multiple choice questions. Is it a timed exam? Yes. But if you go too fast, you miss one word, you get the question wrong, you miss the not or something like that, right? You have to read every single word and you have to interact. And I'm sure, since so many of you took ALS, you already know about that. As we go through these questions today, some of you may have the questions printed out, but many of you don't today. You're still going to try to answer the questions. Remember to mark up, though, when you're practicing your practice questions, wherever you get the question sets from. Mark them up. The more you interact with the written word on the page, the better job you're doing of reading, and the better job you will do in picking the right answer choice. Now, a few more things, and then we're going to try some questions. How do you read the questions? Well, again, you've got to be very, very careful in your reading. Not just underlining. As you go through the question, you're going to be having a dialogue with the facts. What's this fact doing here? Why are they telling me that it was snowing? Or why are they telling me that it was 5 o'clock in the afternoon? Criminal law question, 5 o'clock in the afternoon, we might be thinking about, is it nighttime, right? So have that dialogue. The more that you interact with the question, the better job you're going to do of reading, and the better job the answer choice will pop off the page. Now, you're going to see something as I go through the questions, because it's just the way I do them. Most of you are probably going to go to the call of the question first. A lot of people tell you go to the call of the question first. I don't do questions in that order. And I would suggest, if you're not comfortable with going to the call of the question first, that you try it the other way around and use the method that works best for you. They are two legitimate ways of reading questions. So let me tell you what's good and what's bad about both, and then you use the method that works for you and the one that you're comfortable with. If you read the call of the question first, it focuses you. It tells you what the question is asking about, and so it can have that efficiency. But it also takes a little bit more time. You have to read the call of the question first, and then go to the back to the facts, and then read the call of the question again. So if you are a slow reader, it actually slows you down a little bit more. But again, it does have that benefit of focusing in on where the fact pattern is going. If you start with the facts first, which is what I do, I try to predict the call of the question as I'm going along. And if I'm doing a good job of reading the facts, generally speaking, I will predict the call of the question. If I predict the call of the question, I know I'm going to find the right answer choice. So it actually for me, is an important mental exercise. And what it also does for me, I like to read fast. I always have since I was a kid. I just want to look at the page and move on. Not a good way to approach multiple choice questions. Really bad way to approach multiple choice questions. So if I start with the facts and I pick the facts apart, I actually sit there with a pen or a pencil or whatever and I point to each word like a little kid, because otherwise I'm not reading every word. But if I start up there with the facts and I'm pointing to each and I'm going along and I'm writing notes, it slows me down, which I need to do because I read too fast. And again, it engages me in the fact pattern. It gets my mind working and takes me to the right answer choice. Now, when we get to the answer choices, and this is just a quick sample question. Most of the stuff that I usually do with this question, you probably already know. But we're going to start right with the short fact pattern. 500 words or less. In some subjects, the fact pattern is going to be a little bit longer than others, which is important in terms of your pacing. This is a torts question. It's going to be fairly compact. Your contracts questions tend to be a little bit longer. Your property questions tend to be a little bit longer. But your evidence questions, short, to the point, and a lot of times Civ Pro, short and to the point. Recognize that about the questions, because you have to finish 100 in the morning and 100 in the afternoon. But if you are too mechanical about the amount of time that you devote to each question, you're going to be doing yourself a great disservice. Now, there's a mantra that's out there, 1.8 minutes per question, hit it, move on, right? Don't be too mechanical. 1.8 minutes is probably about right for this question. A short evidence question might take you just 15 seconds. A longer property question could take you a couple of minutes, right? But that longer property question, the examiners, they know what you're going through. And they're going to give you a long property fact question. You're going to look at, a lot of people are going to look at it and they're going to say, property, forget it. And they bubble in B or whatever and they move on. The punchline, the call to question on that long fact pattern oftentimes is very easy. So don't rush through those longer fact patterns. Don't give up on them just because they're a property or whatever your subject is that you don't like. And understand that the examiners oftentimes will give you an easier set of questions at the end of a long fact pattern. So, however, again, approximately 500 words or less. And in these MBE style questions, every fact should matter. It's not, for many of your professors, or at least some of your professors, may have tested with red herrings in their questions, whether multiple choice or essay. And honestly, that's a very valid way to test, because it's real life, right? When your client comes into your office, your client isn't going to pre-screen the facts. Your client's just going to tell you a story, and you have to figure out what's relevant and what's not relevant. But when it comes to the MBE portion of the exam and the essay portion of at least the Florida exam, for those of you taking Florida, every fact matters. There are no red herrings. So stop and ask yourself, what's the fact doing here? It's going to be followed by a call of the question that is going to be specific. And that's true whether it is an MBE style multiple choice question or a Florida essay question. Florida multiple choice, we'll be dealing with those a little later. They are a world unto themselves. But for MBE purposes and Florida essay purposes, a very directed call of the question. Followed by 4 choices again, generally in 2 pairs. 2 yes because, 2 no because. Not always, but usually. Most questions are going to be written in this form. And the key is to match the conclusion, yes or no, with what follows the because, which is the rationale that supports the conclusion. So it's legal analysis in these questions. Once again, if it's yes, then it's got to be the right reason for yes. If it's no, it's got to be the right reason for the no. And how do they get you in this typical question? They'll set it up and you're thinking, oh, the answer has to be yes. And they'll give you a nice rationale, but it's just not the right one. And you'll see this lovely rule statement. Your eye will go right to the lovely rule statement, and it turns out it's the wrong reason for the conclusion. So let's look at this question briefly, pick it apart together, and then we'll start to do the questions that are actually in the packet. And you'll see again, if you like to start with the call to question, there it is right there, battery. But I kind of like to start with the facts and find out where it's going. So let's see what facts we have there that you should be picking out and saying, this fact must matter. So, summer afternoon, we've got a 5-year-old girl. Right away, you see a 5-year-old kid. You don't know yet, well, suppose you read the call to question. 5-year-old kid, what should you be thinking about with a 5-year-old kid? Oh,
The rule of 7.
yeah. 5-year-old kid, battery, intentional tort. Well, think back to your torts class. And you might not remember the name of the case, but everybody remembers Garrett versus Daly, right? He was 5 3/4 years old, right? And can a kid who's 5 3/4 years old, yes, that child can have intent. See, you got to be making those notes right away. And she's in her yard. She runs onto the front lawn of the house next door. Now, it doesn't happen to be the right concept here. However, when she runs onto the front lawn, we're thinking trespass, right? Because that's the intentional entry onto the land of another. So, engage, make those notes. And the owner of the house is on the front porch with his 7-year-old son. By the way, this is an actual case, which is a note case in the Prosser case book. You should understand that almost all of the questions, probably every question that you will see on the MBE portion of the exam is based on a real case. That's how they write the questions. So the more that you recognize cases as you go through these multiple choice questions, the more you'll get the right answer. Because what's the right answer? The holding in the case. That's how they write the questions. So, you've got a 7-year-old kid, he's on the front porch with his father. 7 years old, again, really telegraphing that age is important here. He sees the girl dart to the yard, and he picks up his bow and arrow. Again, these are real facts here. And he goes to the edge of the porch, and he says, if you don't get off the lawn in front of my house, I will shoot you with this bow and arrow. You are thinking about assault. Yeah. Now, remember, the call question is battery, but there's a reason why that assault is very important. Because, anybody tell me? Very good. Transferred intent. Now, some of you may have learned, how many of you in your torts class, if you think back that far, did you learn the restatement definitions of intent for assault and battery, or did you do the common law, one definition for assault, one definition for battery? The separate. Most of you probably learned the separate, right? The restatement combines them, but most of you learned the separate. If you have combined definitions, which is the restatement approach, we don't even need transferred intent. But if you had the separate definitions, which is the way it's usually taught, then transferred intent. All of this conversation has to be going on in your brain as you read the question. So, intending merely to frighten the girl. Helped you out there, right? The boy aims the arrow in her general direction. He pulls the string, hits her in the eye. Transferred intent, right? So, if the girl sues for battery, will she win? Well, your gut's going to tell you yes, no. Yeah, right? But don't get too married to your gut reaction. It happens to be the right reaction here, of course, but sometimes your gut's going to tell you yes or no, but then you're not going to find the right rationale. So you've got to be very careful not to just go with that instinct. So let's look at our choices. And first we've got A, yes, because the boy intended to frighten her. Oh, it doesn't look bad, right? Because we're thinking transferred intent. But never stop with the first answer choice, even if it looks really good, because you don't know what's following. You may have a better choice later on, so you've got to read all four. B, yes, because the boy was negligent when he aimed the bow and arrow. Was he negligent?
That's intentional.
Ah, very good. Okay. Yeah, he probably was negligent, but it's the wrong answer. Why? The call of the question is battery. And make sure when you have a tort question, that's one of the favorite testing tools when it comes to tort, especially if it's intentional tort. They're going to give you one tort in the call of the question and another in the answer choice. You must always match the tort in the call with the tort in the answer choice. So you know B is wrong because negligence is the wrong tort. C, no, because he intended only to frighten her. It's not the right answer, is it? Because transferred intent. And D, no, because he was only 7. Right answer? No, because that's why up at the top, we're thinking Garrett versus Daly. Some of the cases, if you go back into the Prosser case book, which I think all of you have had, some of those no cases, the biting cases, the kids are like 2 years old. So a child can be fairly young and still have the intent to commit an intentional tort. So obviously then, we go back and we know that A is the right answer. Now, as you go through the questions, particularly as you are practicing, don't just rush through the questions. Questions are kind of like popcorn and candy, and they can be seemingly satisfying. You just keep popping those questions and you think you're working really hard. But you don't get any nutrition out of them unless you use them right. So when you do a question, particularly a practice question, it's not enough to say, yay, I got the right answer. I got the right answer because. And sometimes it's more important to know why you got the right answer than it is to know why you got the wrong answer. Because if you got the right answer just because you got lucky or you guessed, not good enough. So make sure as you go through questions when you do them, as you do the question, you engage and you write all of the stuff that I'm talking about, and also as you review questions, make sure that you aren't just saying, yeah, I got it right, or I got it wrong. Any questions at this point? All right, what we're going to do now, I got to fast forward a little. In the materials, I have a lot of stuff about words and the types of words that are used. I'm not going to go through that. I'm assuming that most of you have already spent some time talking about word choices in these questions. We'll, of course, confront them as we go through the questions, and I'm happy to answer any questions you might have. But in the interest of time, let's go to our... All right, now, question number 1. If you're following along electronically, you can do that. If not, you can read right up here. I'm going to ask you to read the question and click in and answer, and we'll see how we did. So I'm going to start. And fire away. numbers, theoretically, you're aiming toward. That's what you're aiming toward. All right, we got 2 minutes, I'm gonna call it. Anybody else? All right. Now, as we go through these questions, by the way, I know that some of you may not have studied yet some of the subjects that we're doing. Doesn't matter, right? Because, and of course this is torts, and it should have been fairly straightforward for you. But as you get to questions on the exam, if you get a question and you go, wow, I don't know what this question's talking about, do it anyway. Try it. Make sure that you at least make the effort, and you might surprise yourself. So let's see how we did on this particular question. And we did very nicely. D is the right answer. I like to start with this question because usually people do get it right. Makes you feel good, right? And you know what? That matters for something. You got to have some confidence in yourself, right? However, of course, you can't get lulled into complacency because torts isn't always that easy, right? Not at all. But let's see what we have going on in this question and why D is the right answer. And I apologize, I've got driver too. I'm not sure how that got dropped in there. But the idea is we've got a kid, he's a fan of music. It was actually a heavy rock band. It's a real case. Actually, several cases, unfortunately, like this. He gets just sucked into the music, and he loses touch with reality and commits suicide. It's a real case, again, taken from the notes in Prosser. Now, the mother wants to bring a wrongful death action based in negligence. So that's the key to this question. It is a negligence-based. Yes, sir.
I'm sorry, this is just a random question. If you see a grammar error,
Yeah.
it's automatically wrong.
No, you know what? It's a good question, and it depends is the answer. The reason I say it depends, I mean, that error right there isn't going to matter in terms of how the question plays out. If you have an error in an answer choice, it's probably the wrong answer choice because there is an error. But these questions, by the way, on the bar exam are vetted very, very, very carefully. They go through iteration after iteration after iteration, and a lot of different eyes see the question before the question shows up on the bar exam. And when the question shows up on the bar exam, usually its first time out, it's what's called experimental, which means that it doesn't count. And you're thinking, but wait a minute. But remember, a little while ago, I talked about scaling. In your ALS class, did you talk about scaling on the bar exam?
No.
Oh, let me take a little bit of time now to explain what that means. You have, of course, 200 MBE questions on Wednesday. 100 in the morning, 100 in the afternoon. And you will, after you complete those 200 questions, you will get a raw score. You got 150 right, you got 50 right, whatever it is, you get a raw score. But when your results are reported to you, you will have a raw score and a scaled score. And your passing depends on the scaled score. Now, first of all, if by any chance, and it's not going to be anybody here, but if by any chance you get less than 100 right, so that's less than 50% raw, they automatically scale you up to 100. But I'm here to tell you, if you're getting scaled up to 100, you're not passing, right? If you get above 100 right, raw, you will then get a scaled score, which gives you anywhere between 10 to 20 extra points. How do you get this scaled score? First of all, these experimental questions, when they're trying a question out for the first time, it may not count. And there will be a certain percentage of those questions on the exam. So you automatically get a point for that question. Everybody does. If If you got the question right already, you don't get an additional point, which is why the scaling varies from person to person. Some people may get 8 extra points, some people may get 15 extra points. Because if you already got the question right, you don't get an additional point. So that's part of what makes up the scaled score. The second part of what makes up the scaled score is if a question doesn't perform properly. What they do after you've all completed the exam and the Scantrons have been marked, they do what's called an item analysis, which we do in my office automatically for all exams that are run through the Scantron machine. And it shows what everybody got right and how many picked A, how many picked B, et cetera, and they evaluate the questions to see if the questions perform properly. If a question doesn't perform properly for any reason, and it could be the typo that you mentioned, they will scale that question out as well. And so, again, your raw score will be increased by anywhere between 10 and 20 points. The lower your raw score, the more likely it is that you will get more scaled score. And think about it for a second. If you get that 175 on the MBE, which happens raw, 175 raw, you got most of the questions right. And so your scaling isn't going to be a whole lot more. You might end up with a 180 scale, right? They'll take that. But if you got that 115 raw, you might actually get a 130 scale. Still not passing, but you see that you get more scale at the lower end.
So the max you can get points-wise for the first day is 200?
Yes.
And then how much is it for the Florida portion?
Oh, yeah. I'll go ahead and talk about that. I was actually going to do it later, and I'll just spend a little time on it now. The Florida portion of the exam, 3 essays, at least the way they've been doing it, 3 essays and 3 multiple choice components for a total of 390 points raw. Each essay is worth 100. Each multiple choice component is worth 30. And that's your 390. What they then do is they scale backwards on Florida, which makes everybody crazy, but they have to take 390 points and squish it down to 200. So that you have 200 for Tuesday, Florida, and 200 for Wednesday, MBE. And then they average that out for the 136 average that you need to pass. How do they scale back on Florida? What they try to do, and we actually took our raw data and had the statistics department here crunch it a while back, and it did play out approximately the way I'm describing it. They try to even it out so that each of the 6 parts on the Florida portion of the exam has equal weight. Remember, your essay starts out with 100 max, your multiple choice starts out with 30 max, so they have to even them out and scale them back to a 200-point scale. What that means is that you could have 2 people sitting side by side who each get 142 on the Florida exam raw, and one person ends up with a 125 scale and another person with a 136 scale, because it depends on where your points came from in terms of the scaling. Makes you crazy, but that's how they do it. Now, what it also means, and again, we'll talk about this when we get to the essay portion, for Florida, what makes or breaks 90% of the candidates, and it's not just St. Thomas, it's across the board in all of the schools in Florida. Most people pass or fail the Florida portion based on essays, even though you have just 3 essays. Those 3 essays matter a lot. When we get, again, to the first Florida lecture, I'm going to talk more about that. All right, so let's look at this question briefly. It should be easy to analyze again. It's a negligence call of the question, and will the mother succeed? A says yes, because he died after listening to the music. What's wrong with that answer choice? What's missing? Causation. Thank you. Many, many years from now, when you are all, I'll be long gone, but you're all walking with your walkers. You've been practicing law for 60, 70 years, right? You won't remember very much anything about what you learned in your bar prep class, and you won't remember much of anything that you learned in your law school career. But you will be able to say the elements of negligence. I don't know why. What do we got? See? Dirty breach, causation, damages. It just sticks in the brain, right? There's no causation. And when you're talking about torts, think about it. I don't care who you had for torts. Elements, 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 right? Doesn't matter who you had for torts. Torts is very, very elemental. All topics in the law are elemental, but torts is particularly elemental. So as you go through a tort, negligence, go through your elements and look for your elements in the answer choices. A is missing that crucial causation element, and by the way, that's exactly what the court said in that case. Again, knowing the case can help you pick the right answer. B, yes, because it caused him, the mother, severe emotional distress. What's wrong with that one? That's the wrong tort. Wrong tort. Wrong tort. Maybe she did suffer severe emotional distress, but it's negligence, not IIED. C, no, because the band did not intend to cause his death. What's wrong? Okay. Call the question is negligence. Intent has nothing to do with negligence. And then D, no, because she can't prove that it caused his suicide. That was the holding in the case. That's the right answer, again, because it reflects the elements of the cause of action. By the way, when you're analyzing a tort question, especially if it's negligence, take those elements in order and make sure they have been fulfilled first before you even think about defenses. Because that's the way it works in torts. Okay, any questions about this question? All right, then. Come on. Hang on a second, I gotta do it this way. All right, so number 2. Let's get that up there. And I'm sorry, let me go back. Sorry. I'm going to give you a few minutes with this part of the question, and then I have to go to the second page because you don't have it in front of you. So maybe make a few notes if you have a piece of paper there. And before I flip the page, anybody want to tell me what you think this question's about? Okay. Glass jars. Good. Okay. It's contracts number 1. And if you have a contracts question, doesn't matter whether it's essay or multiple choice. What's the first question you must always ask yourself? Governing law. Do yourself a huge favor. Governing law, and clearly we got glass jars, they're movable, Article 2 applies, but make sure you address that question first in any essay. So now we'll flip the page and take a look. I'm sorry, there we go. Take a look at what we have there. We'll break this question apart because of the nature of it. What do we think we have going on here? 2207, yes. Now, everybody loves to hate 2207. Think back to your contracts class. Yeah, not fun. You will have at least one 2207 question on the MBE and maybe more than one. And, hate to tell you, they love to test 2207 on the Florida portion of the exam. The contracts is one of the most frequent flyers when it comes to Florida essays. So, is it worth taking time to review 2207? You bet. So we definitely have, because we've got a form, and it's got a paragraph with a 1-year statute of limitations. Under Article 2, the default is 4 years. But you can reduce the statute of limitations to 1 year, no less than 1 year, but you can take it all the way down to 1 year. And processor doesn't respond. Now, let's look at the 4 answer choices. I'm going to let you finish the question and pick what you think the right answer is. Okay, anybody else? Oops, I didn't start it. Sorry. That's my fault. Okay, now go ahead. Okay, anybody else on this one? Let's see what we've got. Kind of all over the place, aren't we? Yeah, and the right answer is B. So let's talk about why B is the right answer. We do know that it's a contracts question. Article 2 clearly applies, and we know it's a 2207 question. So 2207, you got to go in order. First part, 2207 subpart 1 asks whether you have a definite and seasonable expression of acceptance. So the first thing is you got to find out if a contract was even formed. Did we have a definite and seasonable expression of acceptance here? Sure we did. And that means a contract was formed even if that definite and seasonable expression of acceptance had additional or different terms. And we had an additional term here, didn't we?
Yeah.
1-year statute of limitation. Next question, then you drop down to subpart 2. And the question is, what do we do with the additional or different term? I'm going to set different aside for a second. What do we do with the additional term? The first question we ask ourselves is,
The merchants?
thank you, because it says as between merchants. Now, do yourselves a huge favor, and especially when you're writing your essay. When it's important to talk about merchants, talk about merchants, but don't just throw it in if it's not important. Too many times I see people trying to put merchant status into the determination of governing law. No. Article 2 applies to all transactions in goods. It has 13 merchant provisions, special merchant provisions. But all of Article 2 applies to all transactions in goods. Now, those merchant provisions include 2207. And when you get a merchant provision, it's important to ask yourself, do both parties have to be merchants or just one? Not always, but in this case, yes. As between merchants, 2207 subpart 2. Statute of frauds, merchants, exceptions in statute of frauds, both parties have to be merchants. But a firm offer, who has to be a merchant? Just the offeror, right? Just the seller. So, see, look at that subtlety. And I know, you really haven't reviewed contracts yet, so you may not have thought about the difference. But when you're reading these multiple choice questions, see how important it is to read carefully, but also to know the subtleties of the rules. If you don't, then you don't get the question right. So, do we have merchants in this case?
Yes.
Okay, because, what's a merchant? Somebody who deals in goods of the kind, or who holds him or herself out as having special skill or judgment in the trade. We've got people who deal in glass jars, buying and selling glass jars. They deal in goods of the kind. So we do have two merchants. Now, if we have two merchants, the next question is, what do we do with the additional term? What happens with the additional term? It becomes part of the agreement unless,
If they don't contradict.
okay, we have three exceptions. The first one, you're never going to see in these questions, which is if the offer was limited to its terms. Too easy, they're not going to test it. The second is if it's material alteration. We're going to come back to that in a second. And the third, which is what tripped some of you up here, if the offeror objects when? Reasonable time. A number of you picked the 10-day, wherever that 10-day rule was. Oh, right there. No, the 10-day rule is not in 2207. Can anybody tell me where the 10-day rule is? Statute of frauds, merchant's exception. Ooh, that's the kind of thing they're going to get you with. That's such a juicy answer, because you remember 10 days from someplace. You think, well, it's got to be right? No. You've got to match up the right rule with the right situation. So 10-day rule, not applicable here. We get back then to the material alteration. What's a material alteration? Something that results in one of two things.
Surprise or hardship.
Thank you, unfair surprise or hardship, exactly right. And what are the kinds of cases that we're looking for? They used to have cases listed in the comments to 2207. They've taken them out, but there are certain classes of cases that you want to look for.
Price.
Well, no, actually price, because with price you go to 2305 and you reasonable price or as the parties agree. The three categories you want to look for, number one, change in the statute of limitations. It's a material alteration because it could be a surprise, or more likely, it could result in an undue hardship because it cuts the cause of action off early. What else?
Arbitration clause?
Arbitration clauses, absolutely, unless arbitration is a custom of the industry, and they're going to have to tell you. So, statute of limitations, arbitration clauses, and anybody know the third one? Disclaimer of warranty. Okay. Bunch of cases involving disclaimer of warranties. The arbitration cases, you probably had, whatever casebook you had for contracts, you probably had those arbitration cases. But see what you want to do as you're learning the material. Don't just learn the rules, try to have illustrations. The more that you can illustrate, the easier these questions are going to become, and especially if the illustrations come from the cases. Here, the answer is, of course, that, do it this way. Sorry, this is freezing up. Okay. So, sorry. So the answer is B because, there we go, it's timely brought. Why? Because we have a material alteration. Again, material alteration, you're looking for changes in the statute of limitations, arbitration clauses, disclaimer of warranty. Now, by the way, what you do if you have different terms, suppose we had two forms here, one said 1 year statute of limitations, the other said 4 or whatever. There are three approaches, but the approach you want to take is the knockout rule. They knock each other out, and what are you left with?
Nothing.
You default to the gap fillers, right?
Yeah.
4 years. Remember, and 2207 has three parts. First one, formation. Second, what do we do with the additional terms or different terms? And then the third is what happens if you default to the gap fillers in Article 2, and of course, the gap filler for statute of limitations is 4 years. Any questions? And you're gonna have a question that looks a lot like this one, at least one. Okay, number 3, again, it's 2 pages, so for those of you who don't have it, I'm gonna leave this part of the page up first. Go ahead and take a look at the facts here, and then I'll flip to the second page. And you should be seeing something in that paragraph here that will give you the key to this question. All right, I'm going to flip it. No, I'm going to try to flip it. Hang on. All right, so here is the call of the question and the choices. Go ahead and ring in whenever you're ready. Anybody else on this question? All right, let's see how we did. Pretty good. All right, so we know we have a federal con law question. As you study federal con law, you want to approach it just the way you did in law school. You got Con Law 1, which is about powers, right? And Con Law 2, which is about
Big fuss of the Supreme Court.
individual rights, yes? Okay, so you got to think about powers versus rights. And this is a question about powers, right? All right. And it's taken, again, taken from a real case. So what was the key that I told you, and most of you figured it out. The key in the first paragraph was corporation, because we're talking about privileges and immunities clause of Article 4. It is, by the way, the one area on the MBE portion of the exam where numbers matter. You actually have to know the difference between the Article 4, Section 2 privileges and immunities clause versus the 14th Amendment privileges or immunities clause. They will identify by constitutional section. No place else do you need to know the numbers. You do not need to know the numbers of sections for Article 2. You do not need to know the numbers under the Federal Rules of Evidence or the Federal Rules of Civil Procedure. But here, you got to know. And of course, when we're talking about privileges and immunities clause of Article 4, we're talking about what versus what?
Out-of-state citizen.
The state versus citizens of another state. When we're talking about the 14th Amendment privileges or immunities clause, we're talking about the state versus its own citizens. Ooh, look at the distinctions that you want to be making. And of course, we're talking about Article 4 here. And a citizen for Article 4 has to be,
What?
can't be, has to be a person, can't be a corporation, right? Now, let's look at the other. Hang on, or we're gonna lose, if I can find a place to plug in. Just remind me, so I don't trip and fall into that cord. All right. There should be a plug someplace there, but I can't find it. Now, market participant,
From the state community itself.
okay? And market participant we know is important in context of what? Not privileges and immunities, but rather Commerce Clause, good. And when the state is acting as a participant in the market, we have an exception to the Commerce Clause. But another thing to remember about constitutional law, it's kind of like the tort versus tort when we're in that area. They will give you a call to question dealing with one constitutional provision and an answer choice that matches up with another. And you look at market participant, you say, yeah, I learned that. Looks good. Although you guys did not fall for that trap, which is great. But that's the thing you have to watch out for. And B says, yes, because the pursuit of a livelihood is an essential activity under the Privileges and Immunities Clause of Article 4. Is that a true statement of law?
No. Not under 14.
I'm sorry?
Isn't it the other privileges use clause that the pursuit of livelihood?
No, actually, yes, it is Article 4, yeah. And I know you haven't studied this stuff yet, so don't worry if you don't know for sure, but the privileges or immunities under the 14th Amendment, it's the privileges and immunities or immunities of national citizenship, which include the right to travel, the right to vote, it's that kind of stuff. The right to protection of the U.S. Marshal, I always love that one. I don't even know what that means. But when we're talking about Article 4, think about the lawyer case from Virginia and the residency requirement in Virginia. It's the right to pursue a livelihood. So it's a correct statement of law, but it's not the right answer. Why? Because corporations don't have standing under this particular provision of the Constitution, at least not right now. Now, we know with Citizens United that corporations all of a sudden became persons who have a whole lot of power. But for privileges and immunities, not yet. Okay, any other questions about this one? All right, number 4. Can we get there? Oops, sorry. I'm going to flip the page, but you already figured that this question is about? Adverse possession, yes. there are our choices. Let's see how we do, and let's see if we can remember back that far. Anybody else want to ring in on this one? And, you know, it's free, it's anonymous, so give it a go, even if you're going, you know, because you haven't studied properly. All right, let's see how we did. And then I'm going to point out a couple of things about this particular question. Actually, you did pretty well, all things considered. D is the right answer. First thing I want to note is that this particular question is one very similar to one that you likely did in your property class. If you had me for property, you did something very similar. If you had Professor Zeiner for property, you probably did something very similar. So reaching back into those vaults, if you will, can be very important. And it shows you a couple of things. First of all, we have some people who picked A. And you should remember, when it comes to adverse possession, that the disability has to exist when? At the time the possessor enters. So, if you're not reading carefully, or if you don't remember, but see, that's such a simple rule, which I know you learned in your property class. If you're not paying attention, it looks good, because, again, it's a rule. You have to be very careful with those rule-based answer choices. They look really juicy, but a lot of times a rule-based answer choice is a distractor. It's there to get you to pick the wrong rule, or a rule that's non-responsive to the facts. So A isn't the right answer. And once again, the statute did say, yeah, you get 10 years after disability is removed, but the disability has to be in existence when the possessor enters. So B is wrong too. And so is C, which leaves you down here. And I actually had a conversation with Professor Zeiner about this type of question very recently. So we were just kind of talking about questions. The answer, correct answer here, D, is based in fact. And those can be difficult questions, but they're not unusual on the bar exam. The fact that the possessor entered in year 1 is dispositive here. Why? Because the entry was before the disability arose. So, do not, repeat, do not discard fact-based answers. They can easily be the right answer if the fact is dispositive, which it is in this case. Now, a couple of other things to note about this question. Number 1, it is property. We all love to hate, well, I don't, but most people love to hate property. Don't blow off property. maybe you don't get the rule against perpetuities. And honestly, if there's anybody which wishes to spend some time discussing the rule against perpetuities with me, I'm always happy to do so. I like the rule against perpetuities. But most of the bar exam is not about the rule against perpetuities. You will probably have one perpetuities question on the MD. That's it. And so, do you want to spend a whole lot of time cluttering your brain with the rule against perpetuities? Maybe not. But, do you write off all of property? No, because property has landlord-tenant. Property has adverse possession. Property has concurrent tenancies, things that you can learn that aren't so difficult and that are frequently tested on both parts of the exam. So don't ignore property in your studies, and don't skip the property questions on the exam, because again, even though it's property, the right answer may be easy to see. Second, to point out, in property, oftentimes in criminal law, those are the two places where you're most likely to see it, you may have a statute in the fact pattern. If you have a statute in the fact pattern, you must apply the statute that has been given to you, which can be particularly important when it comes to landlord-tenant in property. It can, as you'll see in your studies, can become particularly important when you get to criminal law, because most criminal law classes focus on the model penal code. What does the bar exam test? Common law or made-up statutes. So again, if you've got a statute in your fact pattern, make sure you read it carefully and apply it. Any questions about this one? All right, let's try number 5. Coming up on 2 minutes. Anybody else? All right, see how we did on this one. Very good. What do we have? Of course, we've got an evidence question. Now, you'll notice in this particular question, first thing is, it's not about hearsay. And when you study evidence in law school, you spend all your time talking about hearsay. But I'm here to tell you that hearsay is almost always the wrong answer. And you don't even have it in the answer choices here. Be really cautious about hearsay when it comes to the bar exam. Why? Because in real life, talk to any trial attorney. Many of you have done trial ad or you've done trial work. There's always some other way to get the evidence in. You can't get it in one way, you get it in another. So don't assume that something is hearsay. Think of all the other reasons why the evidence might be offered. And what I'm going to suggest, what also comes out in this question, and we did see sorry, I didn't even show you the right answer. In this particular question, right answer, oh yeah, it is, I did check, it's B. Difference between character and habit. Several important things to note here. First of all, usually when it comes to these multiple choice questions, you want to avoid absolutes, right? Always, never, whatever extreme, right? Because the law's not black and white, it's shades of gray. But the extremes matter here, right? Because we're talking about habit. So the fact that he always stops, that should signal to you that it's habit. And of course, habit is what? It's admissible and it's not hearsay. People get kind of distracted by character, because that's another thing in an evidence class, this big element of character. What I'm going to suggest that you do when it comes to evidence that may help you a lot. There's a 3-step process for thinking about evidence that I did not come up with, but it's a really good approach to use. First step is to figure out what kind of evidence you have, which is usually fairly easy. Is it real evidence, it's the murder weapon, or is it documentary evidence, or is it testimonial? Figure out what it is. And also you may at that point have, things like chain of custody, or possibly some privileged issues. But then you move to the second step, and it's key. If you get the second step right, you will get the right answer, which is to ask yourself, what is the evidence being offered for? Now, as you do so, once again, think of everything that's not hearsay. Impeachment, ownership or control, element of the cause of action, habit. Everything but hearsay. And be very precise. Do we have a criminal proceeding or a civil proceeding? When we're talking about character, that makes a big difference, right? Who's offering it? Is it prosecution or defense? And also, is it being offered on direct or cross? Go through all of those questions first. Don't try to pull the right rule out first. For most people, that's really difficult. Lead yourself to the right rule. What kind of evidence do I have? What's it being offered for? And that will then take you to the third question, which is it admissible? And in this case, we've got habit because he always stops. And is it admissible? Yes, it is. Okay, questions? If not, then let's look at number 6. Okay, anybody else on this one? All right, see how we did. Wow, excellent. Which should show you something. A lot of you probably hated civil procedure, maybe even more than you hated property. I did, I liked property, I hated civil procedure. But you almost all got it right, and you didn't fall for the trap, so I congratulate you. It's a good job on this question. Of course, the call to question is venue. So we know for venue, we don't care about the plaintiff, exactly right. We don't care where the plaintiff lives for venue, not relevant. We do care where the defendant lives, but what's the problem here? They live in different states. So if all of the defendants do not live in the same state, then we have to default to the place where the accident happened. Good. See the steps you go through. You all very clearly went through the right steps here. So again, I congratulate you. And this is, by the way, a fairly typical type of civil procedure question that you'll see on the exam. So that's the good news. Any questions about it? All right, number 7 then. I'm sorry, Chad? Oh, I'm sorry. I will go back. I was trying to judge and I didn't do a good job of that. Okay. We good now? Okay, anybody else on this one? All right. Let's see how we did. Interesting, okay. Yeah, I know. Don't get too excited that you did so well on Taurus. But, of course, that's the right answer. Now, a couple things I want to note about this particular question. You got it right, and that's good, but it's got some layers that you might not have even been paying attention to. So first things first, it is loosely, and I say very loosely, based on a case from Prosser. The particular case that I took it from involved, and you may remember, a guy came over a hill on a dark road and went over the top, it was unlit, and ran into a black cow and killed the cow as he was driving. And he left the cow carcass sitting in the middle of the road and kept on driving, and then somebody else came over the hill and ran into the cow carcass. I thought that was a little too gross, so I switched it to something that actually happened to me, and not to me personally, but to a car I was riding in when I was a kid. Some cases actually came off the top. So the call to question, of course, is negligence, due to breach, causation, damages. And look at what's going on here. You've got two layers of duty. And that's important, because the first duty here was to secure the suitcases to the top of the car. That duty was met, as was the guy coming over the hill. He couldn't have seen the cow, so he was driving with due care. It's what happens afterwards that raises a second duty. And in this case, the question is, do you stop and pick up all the stuff on the road? Well, it kind of goes back to those absolutes we talked about before. There isn't an always or a never when it comes to duty and tort, because we always, except when we're talking about premises liability, we always measure the duty by the reasonable defendant in that factual circumstance. And think about it for a second. If, I always use this example, but if I take my Snapple bottle when I'm leaving and I put it on my roof while I'm putting everything else into my car, and I forget it and I start to drive away, if somebody says, hey, you got a bottle of Snapple on your car, I should probably stop. It might fall off, damage somebody's car, or hurt somebody. But if I get out onto the Palmetto and I'm driving along and somebody's going, am I going to stop? I'm not. Not on the Palmetto, right? If you do, good luck to you, right? So it's what would a reasonable person do in that situation? And so that leads you, as it did for all of you, to the right answer here. Okay, number 8. And those of you who are reading along, if you maybe want to stick your hand up when you're reading the screen, if you want to stick your hand up when you've finished, because I'm trying to watch you, but it's a little tough to do. Anybody else? A little more scattered. The right answer, though, is D. But let's talk about what's going on in this question since we had more incorrect choices. First of all, of course, it's Article 2. Don't get fooled, of course, they do test common law as well. And in particular, we're talking about what kind of contract here? It's a requirements, yeah. Output is the seller will sell to the buyer everything that the seller produces. Requirements, which is what we have here, buyer will buy all the buyer needs from the seller. And of course, even though the quantity is not stated, it's still enforceable under Article 2. And remember that quantity is the one essential term under Article 2. Article 2, when it comes to requirements contracts, says that the buyer has to make its demands, and it uses that word demands in good faith, and if you have a stated estimate, the demand has to be not what? Not unreasonably disproportionate to the stated demands. But that's the key. See how important language is, because it talks about demands. And if you demand something, you're asking for what? When it comes to a requirements contract, you're asking for what? More. I want more, right? That's a demand. When you ask for less, you're not demanding. And so that unreasonably disproportionate language in 2306 is restricted to requests for more. I'm trying to exploit the contract because I got a good price and I'm asking for more and more and more and more and more. If I am asking for less, the question is, am I acting in good faith? The answer is it depends. If I ask for nothing, we want to know why I'm asking for nothing. If I'm asking for nothing because I'm just trying to save money, it's bad faith. If I'm asking for nothing because I'm going out of business or I've shut down that part of my business, it's good faith. And here, that's what's going on. So make that distinction. If you're just saying I'm cutting corners or I'm asking for less, bad faith. If you're going out of business or you shut down that business, that's good faith, and you can ask for nothing. Okay, any questions? All right, number 9. Okay, anybody else on number 9? Kind of stuck here? All right. Very good. Now, couple things to note. Of course, we know it's constitutional law, and it deals with those threshold questions. You would be surprised at how often they test threshold questions on both parts of the exam. I want to give you a little bit of a heads up. It's certainly important for MBE. It's also very important for Florida. As you start to look at those Florida con law essays, always think about standing, mootness, ripeness, threshold questions. And also notice, we'll talk about when we get to the Florida session, the first Florida session, they have been testing federal con law with some frequency on the Florida exam. They go through these periods where they do. So make sure that you can write about federal con law, number 1. And number 2, always look at threshold questions. Now, in this particular case, of course, we're talking about standing, right? And we know that by the time we get to the filing of the suit, that our named plaintiff student is already a resident. He's in state. But
He's not alone, it's a class action.
it's a class action. Thank you. Careful reading right there. Class action. If you have a class action, then as long as you've still got an active member of the class can go forward. And of course, in conjunction with this type of case, you want to consider a case that is capable of repetition, yet evading review. But really the key right there, again, reading comprehension, class action. Again, spend some time on threshold questions. It'll be time very well spent for both parts of the exam. All right, number 10. And we're getting close to the end, folks. I know you're getting tired. We're getting there. Anybody else on this one? All right, let's see how we did here. Yeah, the answer is C. Case-based. When it comes to criminal procedure for the purposes of the MBE portion of the exam, you have to know the cases. Also for constitutional law. As you are studying, as you are reading your materials in these two areas, make sure you pay close attention to the cases that they cite as examples. Why? When it comes to the MBE portion of the exam, if they give you a federal constitutional law question or a criminal procedure question, the right answer has to be the holding in the case. You know, you've had con law, how many of you have taken Crim Pro? Oh, good, all right. So most of you have had Crim Pro. You know what it is when it comes to the Supreme Court. Whatever the justices had for breakfast, that's how they decide, right? They're the Supreme Court, that's what they get to do. So you can't predict in the future. Think about it for a second. You really can't predict in the future what the Supreme Court is going to do. The only way that you can draft and answer questions about federal constitutional law and federal criminal procedure is to base the question on a real case. And we know, if you think back to your Crim Pro class, and I use standing here, I know the Supreme Court has told us technically that's not the right term, but I still use it. To have standing to object to the search, you have to be a resident or an overnight guest, right? And this particular person was not an overnight guest, hence no standing. I'm using, again, the old vernacular. So make sure you spend some time, some quality time with the cases. You will be very happy when you see these questions. The right answer has to be the holding in the case. Okay? Number 11, we're going to do together because you're going to look at it and you're not going to be happy. And plus it's spread out over a couple of pages. So, it's a property question. And I want you first to take a look at the statute. Remember what I told you before. When it comes to property and criminal law, statutes are oftentimes given in the questions. Here's the statute. It's a dreaded recording statute. Tell me what kind of recording statute we have. Okay, we're going to take a little hand vote. Okay, how many of you think it's a pure race statute? Good, because it's not. And they rarely test pure race. It's too easy. So it's going to be notice or race notice, right? And just file this away. Florida is a pure notice jurisdiction. You're going to need that information because they love to test recording in Florida. But the question then is this a notice statute or a race notice statute? How many of you think it's notice? How many of you think it's race notice? Oh, good, because it is race notice. Oh, good. Some of you are going, well, I don't know. All right, how do you decide if it's notice or race notice? It depends on how many people have to record. If one person has to record, it's a notice statute. If two persons have to record, it's a race notice statute. And let me explain what I mean by that. If you have somebody who must record to protect against a subsequent bona fide purchaser, that's the notice part of it, right? If you have somebody who has to record not only to protect against a subsequent bona fide purchaser, but also to be the first person to record, that's a race notice statute. So how many times does somebody, or how many recordings are required, which you can generally get from the language of the statute. Because if it talks about recording just once, it's saying notice statute. If it talks about recording twice, it's race notice. Let's look at this statute, and we've got recorded, duly recorded prior to the record notice. We've got recording twice. It's a race notice statute. Now, if you have a race notice statute, you go through 4 questions. First thing you have to determine is who is subsequent in time, who bought the property later. You're going to have 2 claimants at the bottom of 2 chains of title. And you focus on whoever bought later in time. That's your subsequent person. And that person, of course, has to be a law-abiding purchaser for value. The good news when it comes to both parts of the exam, it's going to be all or nothing. You paid value or you didn't. Some of the more difficult questions in this area deal with somebody who has paid part but not all of the consideration. You will not have to deal with that difficult question. So it's going to be somebody who paid value or somebody who took as a gift or by inheritance. Third question, that person has to take without notice, right? Actual notice, constructive or record notice, and inquiry notice. And then 4th, we add, that's what you would ask, by the way, for a notice statute, Florida. And we add a 4th question, if it's a race notice statute, which is what we have here. Who records first? You're the first in time to record. Which means, by the way, that you have to have a complete recorded chain of title. So every deed in your chain has to be recorded. So now that we know we have a race notice statute, and we know what the steps are, let's pick our answer choice. Anybody else on this one? All right, let's see how we did. D is the right answer. Now look what happened. We took a question that most of you would not have liked because it's recording. Everybody hates recording. And we broke the statute apart first, and then we went through the 4 steps. And many of you got the right answer, which you probably wouldn't have gotten if you just sort of stared at the question. So it's the proof is in the pudding there. Take the time to go through the steps when it comes to these difficult questions. And I got to tell you, you will have a handful of recording questions on the MBE, and they love to test recording on the Florida portion. If you can master recording, you're going to be a step way ahead of other people. And what's your goal? Your goal is to get more questions right than the person sitting to your left and the person sitting to your right. which hopefully is nobody here. Right? So, how do you do that? By taking these difficult questions, and you get them right and they don't. And I promise you, you can master recording, it's gonna be an important part of your packet. One other thing I also want to note, and then we'll go on to number 12, you may have noticed, especially if those of you who are going by hand, that a lot of these questions, D ended up being the right answer. It just happened that way. And I want to stress here, it's really important to understand. Before they changed the testing style on the MBE, what we usually did is try to mix up the question choices and kind of spread it out evenly. So you had same number A, same number B, same number C, same number D. But what you do now when you draft questions, and you'll see it in my answer choices, you go in alphabetical order. So however they fall, they fall. Why did they do that? Number one, so that people wouldn't stop and say, oh, I have too many D's. I better start picking B's or whatever. And also, so that you can't draw a pretty Christmas tree. It is what it is. So understand that again. If you're answering and you see a bunch of, in this case, D's in a row, it doesn't mean you're wrong. Okay, number 12. Anybody else on number 12? All right. All right, very good. Now, it's an easy question, and a few of you did not get the right answer. If you didn't get the right answer, it's almost certainly because you didn't do what? Read the call of the question. Very good. Which statement is least accurate? And I put it here toward the end of the packet on purpose. Because when you get tired, and I know you're tired at this point, you've been sitting for a long time, you get sloppy. You have to be doubly aware as time progresses. You've got to be on top of your own foibles, if you will. If you think you're getting drowsy, then you got to stand up or get a drink of water, do something to get yourself back on focus. And it's an easy question. It's about counterclaims. I don't even have to go through the law. You guys know the rules. It's just reading comprehension. Do not forget about the importance of reading comprehension when it comes to this exam, okay? Any questions? All right, we got just two more, so we're almost done. Number 13. Oops, sorry. Anybody else on this one? All right. Pretty good, but not perfect. This question illustrates a couple of things. Privileges. Make sure that you do spend some time reviewing privileges. Because they certainly are tested not only on the ME portion of the exam, but also the Florida portion of the exam. And we're going to do a set of Florida evidence questions later in the summer. So we have privileges, and we've got two privileges that we're dealing with here: marital communications and spousal immunity. It is really important to know the difference between the two, because they will certainly test them, and we're going to see that we have one in Florida but not the other. And so you're going to have to not only know the difference, but know what Florida has. So we've got couple, and a statement is made, and that statement, by the way, is a what? Is it hearsay? It's a what?
It's made outside of court,
Yes.
out of oath, and it's brought in for the
Who's it made by?
for the truth of the statement assured.
Party opponent, thank you. It's a what?
It's an admission by
It's,
party.
thank you, it's an admission. Ah,
But they're not opponents.
no, it's a party. So it's an admission. It's an admission in this case. And make the distinction between an admission and a declaration against interest, because a declaration against interest is made by somebody who's not a party, right? And it's a party because we've got the defendant. So what are we going to do with that admission? Is it admissible? Because an admission, of course, under the federal rules is admissible non-hearsay. We're going to see in Florida that an admission is hearsay, but it's admissible hearsay. So, does it come in? We need to know whether we're talking about the marital communications privilege or whether we're talking about the spousal immunity privilege. Let's start with marital communications. For marital communications, the communication has to be made when? During the marriage and in confidence, right? Okay? And what about this particular statement? I knew that the TV sets were hot. Was it made during the marriage? Yes. Was it made in confidence? Yes. then you have to ask yourself, who owns the marital communications privilege? Who owns it? Both spouses own it, right? So, in this particular case, can the husband prevent the wife from testifying if it's marital communications privilege? Yes, because he owns the privilege, right? Second privilege is spousal immunity. Spousal immunity, first of all, they have to be married when?
At the time of stating.
At the time the testimony is being given, not necessarily at the time the communication is made, right? And it can be more than just a statement for spousal immunity. And who owns the spousal immunity privilege?
Testifying witness.
The witness spouse, right? All right. And so could the husband prevent the wife from testifying under the spousal immunity? No. But marital communications, yes. But you have to make the distinction. And just to file away, in Florida, we recognize marital communications as we just described it. There is no spousal immunity privilege in Florida. And if you get an evidence component on the Florida exam, which you very likely will, that's something they will definitely test. All right, one last question, and I will let you go. Number 14. Anybody else on this one? All right, let's see how we did. Congratulations. You guys were paying attention. Now, a couple of things to mention about this question, but most of you got it right. And if you got it wrong, it was because?
Confused court with crime law.
I'm sorry?
Confused court with crime law.
Well, or didn't read the call of the question, right? Attempted murder. Now, remember what I said earlier about criminal law. They are going to test the common law. And those of you who had me for criminal law, you know I spent more time than the book really provided on common law principles for this reason. Bar exam on the MBE really doesn't test the MPC unless they give you a statute. Sometimes they will give you a statute that looks MPC based, but many of the questions are common law based. I don't know why, but because that's really not the way it is today, but that's what they test. So, under the common law, of course, we know that attempt is what kind of a crime? Mens rea, right? What kind? specific intent. All attempt under common law is a specific intent crime. And if you had a criminal law class that focused on the NPC, make sure you go back and review the common law rules, because that's what they're going to be testing. Specific intent. A says yes because he did not intend to kill victim. Yeah, that's specific intent. A few of you picked C because did he act recklessly? Sure he did, but nobody was killed. Would that recklessness have been a ground for mens rea if we had a murder? Sure, but it's attempt because nobody died. So specific intent, and that matches up with A and the call of the question. So make sure you read the call of the question clearly and carefully. And again, in criminal law, review the common law. All right, that's it for today. Now, I want to remind you, first of all, everything is going to get, the recording is going to get posted fairly soon. If you want to review it or you have friends who couldn't come today, the materials are already up there. We should, if we don't have them yet, very shortly we should have the materials posted for Wednesday's class with Professor Martin. I want to urge you to attend that class. How many of you took commercial paper or secured trans? Ah, good. Both or just one or the other? Okay, so if you took one or the other, which is great, make sure you come because you're going to get the other, whichever one you didn't take. 2:15 is the start time on Wednesday. Okay, thank you. You guys did a great job today, so congratulations.